Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for week 23 of the Pennsylvania Case Law Update While You Drive podcast. I'm Katie McShane, and this week we are covering cases decided between November 18th and November 24th, 2020. While not all the cases are discussed today, every case decided in the courts this week can be found in the case notes with a link to the full text. Let's jump right in. In the case of Commonwealth v. Knight, the Pennsylvania Supreme Court addresses a number of claims in the evaluation of a death penalty sentence. The defendant pleaded guilty to first-degree murder and a number of other charges following the gruesome murder of a 30-year-old intellectually disabled woman. Following his guilty plea, the defendant had his penalty phase trial, where a jury determines if the defendant should be sentenced to death or to life in prison. The jury is to consider a number of aggravating factors and mitigating factors presented at the trial, and if the aggravating factors outweigh the mitigating factors, the defendant will be sentenced to death. In this case, the jury found two aggravating factors: that the murder was committed in the perpetration of a felony, and that the murder was committed by means of torture. The jury also found as mitigating factors that the defendant lacked a significant history of prior criminal convictions, the fact that the defendant was under extreme mental or emotional disturbance, and that the defendant was under extreme duress or under the substantial dominion of another person. Despite the three mitigating factors, the jury found they were outweighed by the aggravating factors, and the defendant was sentenced to death. On this appeal, the defendant raises several issues. The first claim raised is that the death penalty in Pennsylvania is unconstitutional as it is cruel and unusual punishment and should be abolished. In his brief, the defendant fails to offer any of the constitutional provisions he claims his sentence violates, nor does he offer any arguments as to why his sentence violates those provisions. He instead makes reference and attempts to incorporate a brief authored by another attorney. The court held that such incorporation by reference is an unacceptable manner of appellate advocacy for the proper presentation of a claim for relief. As defendant's claim is devoid of any original argument regarding the constitutionality, the court finds that he has waived this challenge. The defendant's next argument is that the court erred in denying an Atkins instruction. An Atkins instruction advises the jury that a defendant who is determined to be intellectually disabled is not eligible for the death penalty. The court held that the determination to give an Atkins instruction is a three-pronged test: limited intellectual functioning, significant adaptive limitations, and onset prior to the age of 18. Here, the court found that the defendant failed to demonstrate that his IQ fell within a certain range documented prior to the age of 18, and for that reason it was proper to deny the Atkins instruction. The defendant's next argument is that the jury improperly found three aggravating factors when the prosecution only asked for two. The jury found that the murder was committed in the course of two separate felonies and noted that as two separate aggravating factors. The court found that the defendant waived this argument as he did not raise it in his statement of matters complained of on appeal, and secondly, he failed to object to the jury verdict at the trial court level. In his next issue, he claims the judge erred by not allowing defense counsel to read from an expert report during closing. The court finds that this claim was also waived by the defendant as he again failed to raise an objection at the trial court, and secondly, he failed to explain what evidence he was prevented of conveying to the jury as a result of the limitation. The defendant's next claim is that he requested and was denied an Allen instruction. An Allen instruction is given to a jury when they are deadlocked, and the charge is given to attempt to force the jury to come to a verdict. Yet again, the court found that this argument was waived as he failed to raise it in his statement of the questions involved, and there is no separate section for this claim in the argument portion of the brief. Further, he failed to raise any objection at the trial court. Next, the defendant claims that the court erred by not allowing him to ask particular questions of the jury in an attempt to determine if they would only vote for life or only vote for death, in a format known as the Colorado method. The court found no error, holding that the purpose of voir dire is solely to ensure the impaneling of a competent, fair, impartial, and unprejudiced jury capable of following the instructions of the trial court. There is no requirement in Pennsylvania that the Colorado method is used, and the court discerned no error. In his next issue, the defendant claims that the court erred when it allowed the jury to take a number of photographs back to the deliberation room, which resulted in the jury acting on inflamed passions. The court held that photographic evidence of a murder victim is not per se inadmissible. The court must first determine if the photograph is inflammatory, and then, if it is, the court must apply a balancing test to determine whether the photograph is of such as essential evidentiary value that its need clearly outweighs the likelihood of inflaming the minds and passions of the jury. In a capital case, photographic evidence in the penalty phase can have evidentiary value if it helps the jury understand the history and natural development of the facts of the case, or if they potentially rebut mitigation evidence. In this case, the photographs admitted were not gruesome. Rather, they showed that the victim was subjected to a lengthy period of torture before she was killed, and the restraint and humiliation that was inflicted upon her in this regard. The court found that they had essential evidentiary value, and that value was not outweighed by their inflammatory nature. Next, the defendant alleges that the jury instruction pertaining to considering victim impact evidence when weighing aggravating and mitigating circumstances violated the rule that verdicts cannot be based on passion, prejudice, or any arbitrary factor. Because the defendant did not raise this claim at the trial court level when it was given, the argument is waived. In his final argument, the defendant claims that the verdict was against the weight of the evidence and based on passion or prejudice. The court may not reverse a death penalty sentence on weight of the evidence grounds, so that claim is dismissed. Additionally, the court found that the verdict was supported by the factual evidence presented and not the product of passion, prejudice, or some arbitrary factor. In conclusion, the court found that the verdict of the jury, finding the aggravating factors outweighed the mitigating factors, was proper and complies with the statutory mandate for death. There are no grounds on which to reverse the sentence. In the matter of Commonwealth v. Mojica, the court affirms an order denying the defendant's Post-Conviction Relief Act petition. The primary issue in the case is whether the petition was timely filed. The original pro se PCRA petition was filed prior to the time the judgment became final, and at a time when the defendant was still represented by counsel. The PCRA court was mistaken in treating the pro se petition as valid under Pennsylvania law. There were a number of other delays caused by mistakes made by the PCRA court, and the Superior Court found that because the faults are directly attributable to the PCRA court's error, it was proper to extend the time in which to file the amended petition. In the petition, the defendant claims ineffective assistance of counsel. When reviewing these types of claims, courts must presume counsel provided effective assistance. To overcome the presumption, the defendant must plead and prove that the claim has arguable merit, counsel lacked any reasonable basis for the action or inaction, and the defendant suffered prejudice as a result. Failure to satisfy any one prong will result in rejection of the claim. Defendant claims that he requested that his counsel file a direct appeal, and his counsel failed to do so. However, the record reflects credible testimony that the direct appeal was never requested, and therefore there is no arguable merit to the claim, and as such, no relief is due. In the matter of Commonwealth v. Price, an appeal by the Commonwealth, the Superior Court overturns the trial court's order to suppress cell phone records. In 2016, the defendant was arrested in connection with a double homicide. At the time of the arrest, a cell phone was seized from his person. Later, a search warrant was requested and granted. Following a hearing on the motion to suppress the obtained records, the court stated that the affidavit of probable cause did not in fact establish probable cause to justify a search of the phone. Interestingly, the search warrant was granted by the same judge who then later suppressed the evidence. The Commonwealth first argues that the judge should not have been able to essentially overturn his own order granting the search warrant due to the law of the case doctrine. The court rejects this argument as any judge is permitted to revisit their own rulings. The law of the case doctrine prohibits a second judge from revisiting the decision in the same case. Next, the Commonwealth argues that even if probable cause did not exist, the law of inevitable discovery would have permitted the admission of the evidence. Inevitable discovery means that even if the Commonwealth improperly obtained evidence, it is admissible if it would have been inevitably discovered by proper means. Here, the court finds that inevitable discovery applies. The Commonwealth left out of the affidavit information that they had at the time, which would have provided probable cause. This would have allowed them to obtain a second warrant and therefore inevitably discovered the evidence. The order of the trial court granting suppression is reversed. This case is like a double-edged sword. A police officer, when obtaining a warrant, should include as much information as possible so as to develop probable cause to obtain the warrant. However, even if they leave something out, if they can establish that they knew it, they can get the evidence in anyway. From a defense perspective, I think that this opinion allows for sloppy and lazy police work, but alas, the law is the law. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. In the matter of Commonwealth v. Headley, the defendant was convicted of recklessly endangering another person and unlawful discharge of a firearm into an occupied structure after firing his gun through the floor of his apartment and through the ceiling of the apartment below. No one was injured, but the victim was home at the time of the shooting. In this case, the defendant challenged the sufficiency of the evidence as to both charges. As to the charge of rape or recklessly endangering another person, the mere act of discharging a firearm alone does not constitute the crime. However, discharging a firearm near another person in a manner where the projectile could have struck a person is sufficient. After review, the court finds there is no merit to the sufficiency issue as to the rape charge. The facts establish the elements of rape. The defendant fired a gun into the victim's apartment, disregarding the risk that death or serious bodily injury could have occurred. The court finds that the actions created actual danger and not even merely the apprehension of danger. As to the charge of discharging a firearm into an occupied structure, the defendant argues that you cannot be convicted of said crime if you are already inside the occupied structure when the shot is fired. In order to be found guilty of this offense, the evidence must show that the defendant discharged the firearm from any location outside the structure and the projectile moved into the structure. The defendant argued that though they were in separate apartments, they were contained within the same occupied structure, and therefore he did not discharge the firearm into the structure. The court, however, found that a single apartment in a complex is one occupied structure, and a second apartment is a separate occupied structure. This is based on statutory interpretation and the definition of places of abode. As each apartment is separate and distinct from the other, the evidence was sufficient to establish that the defendant fired a shot from outside the structure and the projectile went into the structure. It's clear from this case that challenges to sufficiency of evidence are extremely difficult to overcome when there is no accompanying error on behalf of the court which would necessitate a new trial. The case of Commonwealth v. Davis addresses issues of compulsory joinder and rights against double jeopardy. In this case, the defendant was charged with a felony count of fleeing and attempting to elude a police officer and 6 accompanying summary offenses. At the preliminary hearing, the magisterial district justice dismissed the count of fleeing and attempting to elude. The Commonwealth attempted to withdraw the summary counts, but the judge took it upon himself to enter a conviction to the 6 summary offenses and imposed fines. The Commonwealth later that same day refiled the same fleeing and eluding and summary offenses in a new information. The defendant appealed the refiling of charges, claiming that it violated compulsory joinder as well as his rights against double jeopardy. As an initial matter, the court found that this was a collateral issue appropriate for appeal prior to final judgment on the case. As the appeal was proper, the court addressed the merits of the case. The first issue is whether it was appropriate to file the charges in front of a new MDJ. The court found that the Commonwealth did not strictly comply with the rule requiring that it be filed in front of the same issuing authority. However, that does not automatically entitle the defendant to relief. Here, the defendant was not entitled to relief as he failed to establish how the noncompliance prejudiced him. As to the claims of compulsory joinder and double jeopardy, the court must first find if the defendant was properly convicted of the 6 summary offenses. The court found that after the fleeing charge was originally dismissed and the Commonwealth sought to withdraw the additional charges, the court no longer had jurisdiction to issue a judgment on the summary offenses. As such, there was no prior conviction for which the new charges would run afoul of compulsory joinder or double jeopardy. The court ultimately found that while the Commonwealth made a number of missteps in handling this prosecution, the defendant was not entitled to any relief. Just goes to show that while sometimes procedure matters a great deal, sometimes it doesn't matter at all. Thank you again for joining us this week. I hope that everyone had a wonderful and safe Thanksgiving. We will see you all here back next week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.